Hey, it's Colin Meeks, and welcome to another edition of our podcast. And what I'd like to do today, we in our monthly newsletter, we do a couple of inserts every month. And one of the ones that I get most of the response from throughout the year has to do with estate planning. We have this one sheeter that we send out called the Common Estate Planning Documents. And I'm not an attorney, never been an attorney. We don't prepare any legal documents here in our office. But part of any financial plan that we do for people, we always take into account their estate plans. And normally what we'll do is we'll find out exactly what it is they're trying to accomplish and then hand that off to an attorney and let the attorney do the actual legal planning. So what I'd like to talk to you about today is just a very high level view of some common estate planning documents that you may want to consider for your plan. And like I said, we do hand these off to an attorney. We've got some really great local attorneys that we work with. They are willing to speak to you before you commit to anything. So if you are thinking about your estate plans right now and you just want another opinion, or if you'd like to start a conversation with an attorney, please feel free to reach out to us, and we're happy to refer you to some of the people that we have really long-standing and good relationships with. And the good thing about when we get involved in using an attorney is we can all work together to get you to the finish line, because we're both on the same page as far as we know exactly what you're trying to do. So if you're interested in getting on our newsletter list, first of all, feel free to, you can either email me or you can call the office. You can go to our website. We've got a sign up form right there. Just be sure to put your address in, because this is something that we actually mail out in an envelope every month. So common estate planning documents, the one that everybody knows about is a will, the last will and testament. And that's basically just an instruction book for when I pass away, what happens to my stuff. And it can be filed with the courts. And it's usually, if it's a husband and wife, it could be like a simple "I love you" will, where if I pass away, my wife gets my spouse gets this. If she or he passes away, the other spouse gets this, and then you can include kids and grandkids and all that stuff right on down the line. But the last will and testament is sort of like the most basic of estate planning documents. Everybody should have one of those. Everybody should have an updated one of those. Even if you don't think you have a lot, or you think your situation is fairly simple, you want to be in control of what happens to your stuff. Because if you don't, then you don't know who's in control. The estate is, if you don't have a will, the state's going to write one for you, and it might not be the one that you want. So just keep that in mind. It can, you can go online and do one. I wouldn't recommend it. Something is better than nothing. But if you have a situation where you think you don't have a will, or you want to update your will, do that. The second thing is called a living will. And that's the one where it says, how do I want to be kept alive, so to speak? If something, if I get in a car accident, or if I'm getting sick, or if I have end of life situations, what exactly do I want to have happen? And what can be done to keep me alive? What can't be done to keep me alive? There's other names for it, but living will is just a pretty straightforward way to think of that. And again, I would say when you do legal documents, if you go visit with an attorney, they'll do a complete package for you, which might include a lot of these documents. So you might have a living will. You might have some of the other things we're going to talk about are your powers of attorney. You might have a trust document that's either in the will or outside of the will. But all these things sort of work together. You wouldn't probably just want to go do one without updating or doing the others along the way. So living will is pretty straightforward. Then you've got powers of attorney, and basic two kinds of those are medical power of attorney and financial power of attorney. And they do exactly what you think they would do. Medical power of attorney would allow someone, if you become incapacitated or unable to make medical decisions on your own, who is that person that's able to do that? Who is the person that's able to speak to the doctor, sign healthcare documents, put you in certain facilities and things of that nature? So medical power of attorney is very important. The other power of attorney, the financial power of attorney, is also very important. And that's basically if you become disabled or incapacitated, who can manage your financial affairs? Something as simple as going to the bank and taking money out, or writing a check. If you can no longer sign your name, you would want somebody to have financial power of attorney for you. I can tell you what I went through when my father was sick. Uh, I was I was power of attorney of everything, but having those documents in place and in hand when I would go to his various financial institutions and have to uh, do things on his behalf, it made it way easier because without those, you couldn't do it. He was unable to, and nobody else. It was power of attorney. So having those documents in hand really made it simple. Um, so medical and financial power of attorney, very simple. And then the last document, and don't want to get too much in the weeds of this, but any sort of trust document. And you can think of a trust as sort of there's living trust, there's revocable trust, there's irrevocable trust, there's special needs trusts, uh, all different charitable trusts. So trust is not there's just not one size fits all. And you can think of a trust as just sort of like an empty box. And whatever type of trust you decide to implement, if you decide a trust is right for you, then you just start to put things into this trust or this box, and that box can be once you put it in, you can't get it out. It can be once you put it in, you can pull it out. Um, the trust can spring into effect after you passed away and your will is in effect. It can be a living trust where the trust is active while you're alive. So there's all different kinds of trust that may or may not be for you. And one of the things when I meet with people, they'll come in and say, "Well, I need a trust," and they've heard on the radio, they've heard on TV that somebody told them they should get a trust. And when I start digging a little deeper, well, why do you need a trust, or what do what brought that conversation on? And they'll start to explain things. That'll sort of steer us in the right direction of, one, do they need a trust, or do they, will it really benefit them? And two, what type of trust would be best for them? A really easy way to think about it. I mean, we do a lot of work with families that have a child with special needs, and a special needs trust is very specific. Assets go into that trust, and they are for the benefit of that person with special needs. And it protects it from a lot of things that need to be protected from, and it's got a lot of benefits that allow people to still qualify for certain government benefits if they're available. And the special needs trust is just a really nice, neat way to wrap up taking care of somebody that cannot take care of themselves and cannot make decisions on their own. So those are the handful of legal documents that you should consider. And there's some other things to consider when we look at legal planning. I mean, a lot of times people will say, well, it's in my will, and their will say one thing, and the beneficiaries on their accounts will have a whole different tune. So you really need to be careful of that as well, because if you have a beneficiary on, say, like a retirement account or a 401k, and say it's, person A, say it's your son, and your will says, everything gets split between your son and your daughter. Well, the beneficiary designation is going to trump whatever is said in your will. So beneficiary designations and transfer on death designations, they all come first. So, I mean, I've seen a ton of situations where somebody will say, oh, yeah, I have it all taken care of in my will. Well, let's take a look at your will. And we see, okay, everything is split, between your kids. Then when I go back and look at their investment accounts, well, it tells a different story. In one investment account, it might have their son on there, and the other investment account has a daughter. And in some cases, it has an ex-spouse that they never got around to changing. And that's a huge issue because most cases, people don't want to leave money to somebody they're no longer married to. So just be very careful of when you start to do this type of planning, that everything is sort of talking to everybody. Or everything's talking to each other as far as, does my will match up with the way the beneficiary designations are, and is everything going in exact percentages the way I want it? So there's sort of a high level view of estate planning. And like I said, we don't do the actual legal documents. We know enough to say, okay, here's what you've told us, and here's what we think you ought to do. Now let's get an attorney involved. So if you're interested in getting our checklist or our cheat sheet of common estate planning documents, just feel free to give the office a call. You can email me. I think we'll be able to attach it to the show notes here, but that's estate planning 101, which is the very basics. And once you know the basics, then you can really get into the planning and apply it to your situation. So that's all for today. I really like to thank you for listening, and we'll talk to you next time. Thanks.